It is such an honor to be here with all of you tonight. I'm really honored and overwhelmed, and thank you, Greg, for that introduction. And I think those words of advice from Harvey are very resonant and maybe will come back up in some of the remarks that I intend to make. So thank you to Greg Lukianoff and to Elizabeth Stanley for everything you've done to make this easy for me, and to Joe for taking me out for my pre-talk drink, which is a must. And to my co-presenter, David Latt. I know he was a tough act to follow. And to everyone who worked so hard to make this a great conference. But really, the people I am most grateful for are you, the students. And there isn't any audience I would rather be talking to, because you're the hope. You're relentlessly curious, you're energetic, you are restless, and you're capable of growth and change. My students are actually the reason I decided to be a clinical law professor, which, to take a step back, means that essentially the University of San Francisco subsidizes a pro bono law firm that I run with my students as my co-counsel, and we have actual clients and we litigate their cases. We represent people, as Greg alluded to, who no one really wants to defend. There's no line that we're behind to get to our clients. And it's kind of the way that it was when I was a federal public defender, which was in my previous incarnation, although I can be more selective and I have more resources. But essentially, my job is to instruct, inspire, and to model a very particular form of zealous advocacy for my students. And even though that's my job, sometimes, interestingly, and again, this goes to why I'm so happy to be with all of you, it's my students who teach and inspire me. And so I wanted to talk about one of those times, because as Greg alluded to, I am very focused on enforcing due process rights, and I know that that's something that's near and dear to some of your hearts as well. And in particular, the right not to be disciplined in school or convicted or punished without competent evidence and a fair process. I think we can all agree in theory that this is a fundamental right that should be entirely apolitical, that it doesn't belong to Democrats or Republicans. It's not a red state or a blue state value. But all too often, sadly, people and organizations, I could name some, but I'm being nice, so I won't, sort themselves into camps. So if, for example, the accused person shares their values and is someone they can empathize with, they're down to defend them. And if not, well, maybe the person just deserves what's coming to them, or it's just not a cause that they need to bother themselves with. But here's the reality. The cause of every person who's shouted down or accused and strung up with no due process, that is a cause that should be all of our concern. No matter how offensive the speech, no matter how repellent the accusation. Because the cure for speech you don't like is not to shut your ears and close your mind. That makes you stupid and incapable of rebutting the other side. The response to an allegation of wrongdoing is not to throw the person to the wolves. It is instead to test that allegation through investigation and cross-examination to see if it holds up. I think it is really important to reiterate what seems to be obvious, which is that no gender, race, political party, or ideology has a monopoly on the truth. Those rights apply equally, and so does the responsibility to defend them. No one gets to do an end run around the Constitution. I just told you some bedrock principles of our democratic society. I'm sure they're surprising to none of you in this audience. And yet, my generation is falling down on the job of upholding them consistently, because apparently that requires a bravery that proves to be too much for too many of us. But I'm betting and I'm hoping that your generation is different. And here is my story about why I think I'm right. In 2017, I landed my dream job. I got a tenure track offer at the University of San Francisco, and my job was to direct, as Greg alluded to, a criminal and a racial justice clinic. And I was one step closer to achieving what I like to call the $5 million bet, which is how I monetarily valued tenure, because essentially this is a job that lets you say what you want, do what you want until you're too old and decrepit to do it anymore, at which point you can collect your pension, and I valued that at about $5 million. And what it meant for me was independence and the ability to support my 2 kids as a single parent. But tenure track and tenure, those are 2 different things. And to get from the track into the train station, well, that requires 2/3 of the faculty voting for you, the recommendation of the provost, and ultimately the approval of the university president. And what that means is spending years publishing scholarly articles, performing public service, and getting stellar teaching evaluations. But most of all, here's what tenure requires: not making any waves. And you know, I didn't talk in faculty meetings for 4 years. I did not speak unless spoken to. Because the whole concept was you put your head down, you're a workhorse, you smile cheerfully whenever anybody asks you to serve on some god-awful committee, and you act like they're doing you a favor. And that was my mindset 6 months into my job when I got a call from a friend of mine who's a lawyer across the bay named Dan, and that's actually his real name. In fact, after this is over, I'll tell you his full name and you can go get him because he really did a number on me. He's a civil rights attorney in the Bay Area, and Dan called me up because he wanted to talk to me about this college student who was in dire straits at a California State University. And this young man, a black student on a full athletic scholarship, had been found responsible for violating Title IX by raping another student at his off-campus apartment. I'm going to call this student John, which is not his real name. So being found responsible, as all of you probably know, is the school's way of saying you're guilty. And Dan explained that this finding against John had been made under what was called a single investigator system. So hold on to those 3 words because they're important. I had no idea what Dan was talking about. I didn't really know what Title IX was in the context of campus sexual assault allegations. I didn't know what a single investigator system was. So you probably know Title IX is a federal law providing for equal access in education and preventing discrimination on the basis of sex. It is the law that governs the adjudication of campus sexual assault and harassment complaints because gender-based violence can deprive students of their equal right to obtain an education. In 2018, when I got this call from Dan, the California State University system, and mind you, there are almost 500,000 students in it, they use the single investigator model. And what it means is that there's one person, usually under contract with the school, who interviews the parties, interviews the witnesses, collects the evidence, and decides who did what. That one person plays all those roles that separate people play in the criminal justice system, because in the criminal justice system, we divide those roles to ensure fairness. Here, the single investigator in John's case confronted these undisputed facts. John's teammate had a white ex-girlfriend, and I'm going to call her Jane, not her name. Jane matched with John on Tinder. She came over to John's apartment, they had sex, and 3 days later, she came back and they had sex again. 3 weeks later, Jane, who had reconciled with her boyfriend, claimed that John had raped her the first time. John adamantly denied her account, and Jane's boyfriend said that she was lying. In a string of text messages between the 2 of them, Jane went back and forth about what had actually happened. And at one point, her boyfriend asked her point blank if John had raped her, and she texted back, "I wouldn't say rape." But the investigator believed Jane several weeks later when she said it was, and she found John responsible. And as a result of that, he was facing almost certain expulsion, and he had days to appeal. John, who was one of the first of his family to go to college and had spent some of his childhood homeless and sleeping in cars, had no money and no lawyer. Dan told me that this investigator, in believing Jane, had violated some of the rules that govern this process. She had not let John see Jane's complaint, and she had not let John see Jane's rebuttal to John's defense. She had also refused to consider evidence that John had offered in his defense. Then Dan told me something else, and it made my blood run cold. He told me that Jane's allegation had become public, and that a group of students had made hundreds of posters with John's name and his face, and the word rapist printed in huge black letters. and then they had plastered the posters all over the campus. This campus was less than 3% black, and the town was less than 2% black. Ever since, John had been hiding in his apartment. In an email to the title Investigator, he pleaded with her to investigate, saying, quote, "People die behind things like this." And she wrote back, "Investigating what happened to you is not my job." John was afraid to set foot on campus, and he was failing all of his classes. And then another accuser came forward with a rape accusation, and the school, without investigating it, suspended him indefinitely. So that was the situation that Dan presented me with. And he asked if my students and I would represent John pro bono. And I said, I didn't think that we could. I had my reasons. I told Dan the truth. I'd never litigated a Title IX case. I didn't know the law. I didn't think we could draft an appeal in less than a week. This was not my area of expertise, and we had plenty of other things to do. But as I explained my reasoning, I got increasingly uncomfortable. Everything I was telling Dan was true, but it wasn't the whole truth. Here's what was going through my mind. This was the height of the Me Too movement. John was, for all intents and purposes, a convicted rapist. Now there was another accuser. The school was 6 hours away upstate. My tenure application, which included all of the righteous cases that I was litigating with my students, was due in the fall. This was not keeping my head down. Taking this case meant inevitably making waves. It meant wading into the culture war that Greg was alluding to. I had defended men accused of rape and sexual assault when I was a federal public defender, and I knew how hard it was on so many levels. But back then, it was part of my job, because when you're a public defender, you take everyone. And now, my job was whatever I said that it was. And I wanted no part of this case. But Dan kept pushing me. So finally, I told him, you know what? I'm going to talk to my law students. 2 of them happened to be in the clinic. They were outside my office, and they were both women. And I was confident that they were going to agree with me and give me the ammunition that I needed to tell Dan no. So I told my 2 students the story of John in some broad strokes, but not really about the legal process so much. And my student Jessie, which is not her real name, she wanted to know what had happened at John's hearing on the campus. And I said, there was no hearing. And my student Donna wanted to know what the fact finder had decided after hearing all the evidence, and I said there wasn't a fact finder. There was just the investigator. And Donna said, so one person decided everything? And I said, yes, and as I said it, it hit me all over again how messed up that was. That one person was the detective, the prosecutor, the judge, the jury, and the executioner. Jessie wanted to know if John was still hiding in his apartment. I said I didn't know. Then she said, well, you told Dan that we would represent him, right? And I opened my mouth to say no. And she said, tell Dan we're taking this case because we're the racial justice clinic. And John is exactly the kind of person that we should be representing. And I will tell you that in that moment, I felt profound shame because honestly, a 28-year-old student shouldn't have had to tell me that. I was afraid. I was afraid to do the right thing. But my third-year law students, they made me do it. So we took John's case, and the next 18 months was one of the most bizarre legal odysseys that I have ever been on. We appealed, and we won, and the case was sent back down for the investigator to fix her errors. But then something very unusual happened, which is that Jane decided that she wanted to go to court in addition to having the pending Title IX case. And she wanted to go to court because she wanted a permanent harassment restraining order entered by a judge against John, which would put him in a criminal offender database. And when you do that and you go to court, all these rights get triggered. And all of a sudden, John had the right to see the evidence against him and to cross-examine and to call his own witnesses. And he had me, and I was a trial lawyer. So we went to trial. And I cross-examined Jane for about 2 days. And at the end, it emerged that there wasn't any evidence to support this permanent harassment restraining order because she was saying he had violated the no contact order that the school had put into place, and there was really no evidence that he had. But in getting to that issue, we got to relitigate all of the allegations. And as it turned out, there were many other things that she had also not told the truth about. And to be blunt, on the stand, her account of what happened completely fell apart. Cross-examination has been called the single greatest engine to uncover the truth, and it fulfilled that function in this case. The judge ruled for John, and there was no restraining order. I thought naively that this was going to make all the difference because, of course, the case was still pending with the investigator. And so we presented her with the transcript and all of the new evidence to consider, but she refused to consider any of it. She said none of it, including the inconsistencies and false statements made under oath, was relevant. And she once again found John responsible for rape, and so once again, we appealed. And I should say that the second accuser's accusation against John was so unfounded that even this investigator declined to find it credible. And yet, our efforts to overturn his de facto suspension were unsuccessful, and so he was not able to go to school. He was not able to go to school all that spring. He was not able to practice with his team over the summer, and as we started entering into the fall, it was clear he wouldn't be able to go back to school then either. So this was in the fall of 2018, and honestly, I was starting to feel pretty hopeless about the whole situation. And the appeal that we were presenting was internal to the school. We weren't in court. Meanwhile, in November, the Trump administration issued some guidelines, these proposed regulations that basically were written to do away with the Obama-era guidelines that the California State University had been operating under. So to be clear, those guidelines, and they were called the Dear Colleague letter, they allowed things like a single investigator system. And the Trump administration came in and said, we're not doing that. That's not consistent with due process. And so we're going to require that these schools have cross-examination, and we're going to require that they have a neutral adjudicator. So I'm reading about these proposed regulations, and I once again find myself feeling deeply uncomfortable. If enacted, they restored some semblance of fairness to a process that I knew firsthand from representing John was a total sham. But they came from the Trump administration. They came from the Secretary of Education, Betsy DeVos, who was widely and, in my opinion, justifiably despised, appointed by a man who bragged about grabbing women by the pussy. I hated everything about the Trump administration, and this was before the insurrection and the double impeachment. I hated everything except, apparently, these proposed regulations. Well, when they came out, most of my friends, who are, of course, feminists and Democrats, I live in San Francisco, they quickly condemned these regulations. They said they were written by rape apologists to let rapists off the hook. And listening to them, I found myself shaking my head and thinking, this is not a political issue. This is not about red or blue. And I thought about my friend and mentor, the Harvard law professor, Janet Holley, who has assisted students in Title IX cases. And she said, I've assisted men of color, a dreamer, a homeless man, and 2 trans students. How can the left care about these people when the frame is mass incarceration, immigration, or transpositivity, and actively reject fairness protections under Title IX? I want to pause for a moment on the racial justice aspect of these remarks because in many of these cases, including John's, these are cross-racial accusations. And while the federal government does not collect data on race and Title IX outcomes, the anecdotal evidence that we have is disturbing. An analysis of sexual assault allegations at Colgate, for example, found that while only 4.2% of the college's students were Black in 2012 and 2013, 50% of the sexual violation accusations reported to the school were made against Black students. And Black men were 40% of the students who went through the formal disciplinary process. 4.2% of the population, 40% of those disciplined. And I can tell you, from 20 years of representing people in the criminal legal system, and as you probably know, living in this world and as students of history, that we have long over-sexualized, over-criminalized, and disproportionately punished Black men. And so, it should come as no surprise in a setting in which these protections for the accused are greatly diminished that this shameful legacy continues. I started reading and hearing about more of these cases, other Black men, just like my client John, who had been publicly adjudicated rapists, their safety threatened, and convicted under a single investigator system and expelled. Up until that point, our advocacy on John's behalf had been more or less a private matter. But I thought, with John's permission, that it was important to make a public statement about what was happening to him and other people like him. And I wanted to make a bigger argument about why the current system was unfair and racially biased. And John agreed. I wrote an op-ed that was published in the New York Times on December the 4th, 2018. It was called, "I'm a Democrat and a feminist, and I support Betsy DeVos's Title IX reforms." You can imagine the response this engendered. I was told by many people that I respected not to write and publish this op-ed. I was told I would be condemned by my allies on the left. More than one person pointed out that the ACLU, the 100-year-old bastion of civil liberties and the embodiment of the belief that you are innocent until proven guilty, had tweeted out angrily in response to these regulations by the Trump administration, quote, "These regulations promote an unfair process inappropriately favoring the accused." So I mean, if the ACLU is not on your side. I was told I would lose friends. I was told I might not get tenure. The night before that op-ed ran, I did not sleep. I had a few drinks. And you know what? I ended up going through with it anyway. And I did it really because of my students. Because the idea that my clinic would only take Title IX cases on the down low and never talk about these issues and the larger racial and due process implications and injustices that they surfaced, really honestly doing that meant that I was a coward and a bad role model, and I did not deserve my job. And you know what? There were consequences to this op-ed. As you can imagine, anyone who's familiar with social media, people had things to say. Not all of them were very nice. In fact, I was widely condemned. I was called the feminist antichrist, a rape apologist. I got death threats on my answering machine at work. People have to know that nobody ever picks up their work phone. But anyway, I would go to work and have these messages, mostly from women, which is so weird, threatening to burn me alive and bury me deep under the ground. And I did lose one friend, although, I mean, to be honest, she kind of sucked, so whatever. But I think, and this is really echoing Greg, I think he and I must have been somehow in tune, but I honestly think that the people whose opinions mattered the most to me at the end of the day, the people that I truly respected in my field, in my friendship cohort, they understood what we were doing in the Racial Justice Clinic and why. And my university, which is one of the most progressive places I have ever worked, and believe me, I worked in some progressive places, they understood. And 4 months after my op-ed was published, my colleagues did vote. They voted to grant me tenure unanimously. My dean, the provost, and the university president accepted that recommendation. So meanwhile, back at John's university, it was one delay after another while this appeal was going on, and that was really frustrating. But at the end of the day, that delay inured to his benefit because in January of 2019, a court of appeal in California decided a case called Doe versus Ali. And in that case, they invalidated the single investigator system that the California State University and almost every other college and university in California was using. They said it violated due process to not have cross-examination and not have a fair and neutral adjudicator. And what that meant was that the California State University was going to have to start all over again with completely new procedures that they didn't have. So they were reeling. So John, Jane, and the lawyers, we went to the bargaining table. I can't speak to the specifics of the settlement other than to say that John was not found responsible for sexual assault or any violation in connection with Jane or the other person who accused him. And he left school as a student in good standing. 18 months later, it was over. Since John's case, my students and I have taken on a number of Title IX cases. In every single one of them, our client was Black or Latino and facing a cross-racial accusation. As far as I know, we're the only law school in the country that takes these cases on behalf of the accused. And so because of that, we often litigate outside the state of California. Our representation is the difference between a fair and an unfair process. These students are not entitled to a lawyer. They are not entitled to legal advice. But having a lawyer is the difference between being found not responsible and having an education and being found responsible and getting expelled. And make no mistake, if you are found to be a Title IX sex offender and expelled, that is the end of your education. There are costs to speaking up and giving assistance to people who are presumed guilty and condemned as rapists. There are costs to saying, no, I don't believe that any one gender has a monopoly on the truth. And let me pause here and say this. Rape on campus is real, and for too long, women and girls have been ignored and their allegations have been shoved under the rug. And the Obama administration's Dear Colleague letter, it was attempting to grapple with that problem. I don't think they did it correctly, but the intentions behind that letter were good. Disgusting and reprehensible things have happened to too many people on college campuses. But the answer isn't to let the pendulum swing wildly the other way and make students like John pay a retroactive price. A sexual assault allegation has to be treated just like any other allegation. It has to be tested against the evidence, and the other side has to be heard. A neutral third party has to decide. The cost of not voicing what should be obvious, the cost of turning our backs when it comes to certain kinds of allegations, that is a price that we cannot afford to pay. When that happens, when we are silent, when we distance ourselves from people like John and let them be railroaded, we are betraying the values and disrespecting the rights that our country was founded on. And now the Title IX battle is heating up all over again. Last month, the Biden administration decided that they wanted to rescind the Trump administration's regulations, rescinding the Obama regulations. Imagine being a Title IX administrator. I just feel like your head would be spinning. And replacing them, of course, they would like to bring back the single investigator system. Leftists and feminists everywhere were cheering, but not me. The ACLU barely made a peep. FIRE, which has defended the Trump regulations in court, spoke out forcefully, and that's a big reason why I said yes to this invitation, because we need organizations like FIRE. We need organizations that believe in rights first, politics last. And quite frankly, the ACLU is not that organization anymore. And so someone has to step into the breach. Sometimes I think back to that fateful conversation with my friend Dan, who I hope you all dox, in February of 2018. And I think that my legal and my professional career would look a lot different if I had just firmly and politely told Dan and John no. If I had said, no, I'm sorry, this is not my job, this is not my fight. If I had said, I have too much to lose, and right now I just need to keep my head down. But if I had to do it all over again, I would do exactly the same thing, except I would not hesitate to take a case like John's only to have to be shamed into it by people like you. Thank you.
Now we will begin our Q&A period. If you have a question, please raise your hand and please state your name and school.
Hi, thank you for being here. Is this on? Oh, okay. My name is Emily Garcia. I go to the University of Georgia. I know you said that you agreed with some of the Title IX regulations put out by the Trump administration. I'm wondering, is there anything that you would have, modified to make those regulations better, more conducive in giving due process to the accused?
Yeah, it's interesting. So when those came out, as you can imagine, the outpouring from a number of women's organizations against them was overwhelming. And so there's a group of law professors, including Professor Holly at Yale, and I joined with them, and we submitted some comments, like the dorky thing that only law professors would ever have time to do, and made some suggestions, and we did have some suggestions. I mean, I personally think that it's essential to have cross-examination. I don't think it's essential for the students to be doing it. I think that you can have someone else doing it. I think you can submit questions, so we propose those modifications. I was also very focused on getting the Trump administration to back off from the Obama-era prohibition against any sort of mediation or restorative justice, because I have found that in some of these cases, not all of them, but some of them, the best way to deal with what's happened is actually to have a restorative process, and so I fought for that because I thought it was really important. And oftentimes this adversarial system, particularly when it's some kind of pre-existing dating or sexual relationship, is conducive to a better resolution. And then, you know, I think we differed because the Trump administration had these very strict jurisdictional requirements that we thought maybe didn't go far enough in protecting students, so we also made that point. So we tried to say, kind of overwhelmingly, we think this is good, and then here's some other improvements that we would like to see happen.
Hello. My name actually is John, and I have actually been through one of these things, and I used to be on the board of an organization called FACE, and I have been counseling students on these issues and advocating on the Hill for years. And I just want to put that out there because I know there may be other people that have been in this situation, and you may not want to say it out loud. You're welcome to, you know, pull me aside and we can talk at some point. But I do have a question. I actually opposed the DeVos regulations, and the reason for that is when I was in Australia, there was a similar case that came up. The students sued, and the court essentially found that a university could not investigate a student for criminal conduct, that there is no Title IX in Australia, you just have to go to the police. And I would like to envision a world like that in which admin law just plays a much smaller role in my life, and I wonder if you think A, that's achievable, and B, if you think that's desirable.
So if I understand your question, what you're saying is you disagree because your feeling is these should always go to court and there shouldn't necessarily be a Title IX campus adjudicatory process, period? Is that
correct? So
okay.
I don't buy the idea that the Commerce Clause gives the Department of Education the authority to regulate these things. I don't buy the disparate impact doctrine. I don't buy any of that stuff.
I mean, so I think the issue with your legal position is that every court that's been confronted with the question, you know, does Title IX apply in the campus adjudicatory system, has said yes, it squarely does, not just Title IX, no discrimination on the basis of sex and education, but also writ large, there's this line of Supreme Court cases that goes back to the 90s saying, and by the way, Title IX encompasses sexual harassment, then it encompasses sexual assault. So you have this line of precedent essentially giving schools the jurisdiction and really not just the adjudicatory authority, but the obligation and responsibility to adjudicate. And I think unless and until the Supreme Court overturns that line of precedent, I don't see how schools get out of the Title IX business, or the government for that matter. And I think one thing that's been so interesting to watch is these schools flail as they try to do this, because there's this weird situation in which they're saying we're all about education. They like to use words like responsible and not responsible to make it sound like it's not that bad. Except that, I mean, honestly, a lot of my clients would rather be convicted of a non-sexual felony and then they could still go to college someday. And so there's something about the whole thing, the language, and that it's not really about punishment that's so false. And so I understand your frustration with that, and yet I think that the law is very clear that they have to operate in this theater. And so then the question becomes like, well, how do they do that? And of course, you know, they keep saying, well, we don't have the resources to do this and do that, and we're not a courtroom. And I suppose that's true to some extent, but your point is that these are very, very serious allegations with life-altering consequences. And so if you're going to be in the business of doing this, there has to be some process. And I hear you when you say like nothing's going to be good enough, you just go to court or not. But I don't think that that's where we are legally, if that makes sense.
Hi. So I'm wondering if you included the aspect of cross-racial situations that you were discussing with us when you were handling these cases, and if so, if you think that could have been helpful, like for instance with your colleagues or peers at school, like your other professors, because just on the basis that it kind of sounds like something that could be coming in from the left?
Yeah, so it's a racial justice clinic, and so we have a very particular focus. And I think absolutely, at the end of the day, probably to my colleagues, it made a big difference, right? And I think also just being able to sort of explain why these procedures are really deficient, it helps to be able to make this overarching case about how implicit bias plays into various kinds of accusations, but then it sort of doubles or triples when it's cross-racial. And so I think being able to explain it in that way, well, it completely fell on deaf ears at John's school. They could not have cared less. I do think it was an issue at the trial, for sure. It was a big issue. And I think it's been an issue or a way to get some people to move off of their very hardened positions if you bring the racial justice aspect of it into it. That said, I think the sides seem like, pretty polarized, which is why it's hard to exist in this like very particular space.
Hello, and thank you so much for speaking with us today. My name's Ellid, and I'm a rising 1L at University of Cincinnati's Law School. So I'm excited to start that fight too, and I've often worked with the Ohio Innocence Project and wrongful conviction cases, so I share some of those values. As someone that also faces that occasional cognitive dissonance of being a feminist, a leftist, but also a fervent believer in due process protections, I'm curious how you believe that we can use restorative justice practices to prioritize both parties in a case, specifically sexual assault cases, particularly when both parties experience the event or events differently and truly stand on those convictions, because I think sometimes those cases aren't as black and white as we want them to be.
Yeah, that's a great question. So you know Mark Godsey, I take it. Yeah, he's great.
He's a friend.
I love Mark. So we had a case where it was interesting. We had a case, it started pre-Trump regulations, and then it dragged on. The other thing is they say that they're supposed to be prompt and fair. I've never seen one of these things take less than like 5 years. But anyway, it dragged on for so long that they had to drop the prohibition on restorative justice and say that we could use it. And so after wrangling and wrangling, we asked, would the accuser, would she be interested in doing it? And she was. And it changed the entire situation. And it's exactly the way that you said. I mean, they were both very young. They were both very inexperienced. He was an immigrant, a first-gen person. He had been the victim of sexual assault himself. Like, there was just so much going on. She had her issues going on. It was kind of the first relationship for both of them. And there had been a lot of miscommunication, but they had experienced the incident very differently. He felt incredibly responsible, but interestingly, basically like confessed to the wrong things. So there was just a mismatch in the accounts. And once we got out of the adversarial process and into the restorative process, and there were trained professionals, restorative justice facilitators, who were meeting with them individually for hours and hours and then bringing them together, that case did successfully resolve. And it was a huge relief because, as you say, it was like they both felt that something had gone really wrong, but they expressed it in very different ways. And I think just like from my client's perspective, he wanted to make amends, but like his own version of what had happened just was not like matching up. But even just being able to sit in the same room, or I think they were on Zoom because it was the pandemic, and kind of being able to hear and share experiences, they were able to kind of process it. And that, I'm not saying that that's like the perfect solution, but it's actually the best resolution I've ever seen. I've never seen a case other than that one resolve where everyone coming out of it wasn't just unbelievably damaged.
My name is Willoughby. I go to Stanford University, and I'm an undergrad. I remember when the Trump administration's changes to the Title IX regulations came out, and initially I really agreed with them. I thought expanding the process so that you reduce the rate of false accusations is great, but the past few years at Stanford has somewhat changed my mind. I've seen the really poor way my university deals with the situations and the number of horrible perpetrators who get away with the most awful things. And a big reason for that is that people are afraid of going through the process, and so they don't report. Now, obviously, you could say the solution is, well, just report, but these people are traumatized. I mean, we have a lab at Stanford that is trying to use psilocybin to treat PTSD of sexual assault survivors. So just saying, just report doesn't seem like the best solution. Any policy is going to be a balancing act between false accusations and people not reporting. Why do you think something like the Trump era guidelines is the right balance in that?
I mean, look, you're right. It is such a horrible process, and you're 100% right that I told you one story and you could tell me 10 stories where it was a really horrible thing that happened to someone and they were absolutely victimized. And we haven't even gotten into like things that happen in the LGBTQ community. I mean, this is a very complicated situation, and there are real harms that are perpetrated. And you're right, a lot of people don't want to report, and you know what? I don't blame them. And I don't know what the answer is. I mean, we can't get rid of it, as your colleague suggested, because the Supreme Court has said that we can't be doing that. There has to be some kind of accountability, but what we were doing in the Obama era, to me, seemed that my experience with John's case, it was radicalizing for me, because it just felt like all they wanted to do was expel him as quickly as possible. And it was literally like a kangaroo court, except there was just a kangaroo and not a court. So I hear you when you say, like, and yes, now we have these procedures, and now people they feel silenced and they don't want to report. And I think that we're in this weird liminal space. And also because these Title IX coordinators, as I've said, like, you know, they turn around and the law changes on them. And, you know, there's a case now, the Doe versus Ali case in California is up in the California Supreme Court. So who knows, like in a few weeks, maybe there'll be more rules that we have to. And so because there's all of this chaos and uncertainty, and because the cultural norms are shifting, and because we're in the middle of a culture war, it makes it really, really difficult. And I don't know what the answer is, other than I feel like we've got to struggle through this process and get to the point where the people who are in charge of adjudicating these cases do it with some degree of fairness and sensitivity. And I also think that, in my experience, that's a rarity. And I do not doubt for a second everything that you're saying, and I think you're very correct, and you importantly point out that there's a whole other side to this story.
Hi, I'm Sam. I go to Tufts, and I'm a sophomore. My question was about your experience with the fallout. I want to put this like the best way possible. I've seen a lot worse happen to people who did a lot less. So what do you think it was about you specifically that maybe made it different and made your actions be perceived differently by the public and your friends and colleagues?
I think I got a little bit lucky in the timing, although at the time the timing felt horrible to me. But the truth is that for all the people on Twitter screaming that I was a rape apologist and hated women, and, you know, the people who wanted to burn me and bury me alive, which I've never understood. I'm like, well, if I'm already burned, why? It seemed like an extra step, but, and unnecessary. But I think for all those people, there were all these people who were like, look, I've known this woman for 20 years. Like, she's not my favorite person, but whatever. Like, she's been doing this work for 20 years. Like, I had a long track record of being an advocate as a federal public defender. I had run an innocence project. I had exonerated someone. So it was just hard to kind of look at my life and be like, she's a traitor to the left. Like, she's a horrible person. I mean, there are still people who say that, but I think in general they ended up being in the minority because I had banked enough capital. But I think if I had been, 28 instead of 48, it would have been a lot different for me. And that is, this goes to this kind of things that you all are up against. And my heart goes out to you, because it's like, you don't have a track record. You're young, you're going out into the world. And so it's really difficult to make these decisions knowing that, like, maybe you're not going to get the benefit of the doubt. I had my colleagues and my friends who'd known me for decades who, that most of them went to bat for me. And like I said, the one sucky one who didn't, like, you're probably better off, right? But I think it's much more challenging to be you, much as I would prefer to be youthful. I think that was the thing that I had in my corner.
Hi, Scott Bell from Indiana University.
I was just wondering, like, with regard to the flip-flopping that we've done under the Biden or the Obama administration and the Trump administration, and now again under the Biden administration, about these policies. Do you think that we're just stuck in sort of like a permanent doom loop, or will we ever actually be able to come to any sort of consensus about this?
I think as long as we have people controlling the levers of power who are over the age of 70 or 80, we're going to be in this loop. I really encourage all of you to go out and run for office. It is time for a change. I am done. Yes, that's the answer. These people, man, they've been there too long. So if we keep them and we keep electing them, then yes. And unless younger people who have better and different and more robust ideas are going to get in there and do something different, then we are going to be stuck. But the nice thing is, well, it's not nice, but eventually, you know, everyone's life comes to an end and then new people come in. So I'm hopeful. That's why I like you. That's why I like students.
You definitely seem, well, first, thank you so much for coming and talking to us. You definitely seem really passionate about this, but what's like the flip side of that in terms of the emotional toll that's happened? Because I feel like in terms of people who want to be lawyers in the future, like you have to be ready for that. And also, like as a young woman hearing some of this, it was hard to take initially, but I just wanted to say thank you for like, you know, bringing your speech here. But has that affected, you know, your personal life in different ways? And thank you.
Yeah, I mean, it was interesting. The thing about John's case that was affirming for me was that my students were so down with this cause that they were really fervent and they gave me a lot of strength. But I will tell you that it was difficult. I mean, it was incredibly stressful. And actually, I didn't tell this part of the story. It was so bizarre being in this universe. Mostly, of course, I was used to being in court, and while I personally feel that oftentimes judges and prosecutors are not fair to defendants, there are certain rules that people have to follow and deadlines and things like that. But weird things would happen to us, like when we first came in and he had, I think, 5 days to appeal, I asked for one more day, and they responded by taking away 2 days, which is not a thing. And they told me that at 4:30 at night. They said, your appeal is now due at 11:59 p.m. And I had my jacket on because I had to go pick up my kids from elementary school. And I had to call my ex-husband and ask him to drive 45 minutes from his office in Oakland to go get our kids. And as this was happening to me, I thought, you know, I should just close the door to my office and do this in private. And then I thought, you know what? I think my law students naturally need to see what this looks like, because this is a very messy, stressful situation. Practicing law is no joke, and they should be able to understand that, like, there are some really hard sacrifices. So I made the call in front of them, and, you know, God bless my ex-husband, even though as a lawyer he literally couldn't believe it and was like, that's not true, because it's not a thing. He went and got our kids. So yeah, there are all kinds of things that happen, and I think also just the judgment of, you know, saying that this person is your client. But I think at the end of the day, I think it's just really important to be transparent and real with your students about the kind of toll that it takes. And, you know, we had to go up there for this trial. It was only supposed to be 1 day. I wore the same suit the second day in a row, which I'm sure men get away with all the time, but I had never done that because we were back there the next day and we had to, you know, make all kinds of accommodations. And I think that, like, you know, they could see that it was really stressful. One of them did the opening. They helped me write my closing. So I guess what I want to say about that is, like, I think it's important when you have some degree of experience and you're in a position where you can maybe mentor students to really be honest with them and not make it seem like everything is so perfectly together, because that's a lie. And then also when they try to go out on their own and have families and lives, it'll seem impossible to them. So I just made kind of a conscious decision that, like, they were going to get to see what it actually cost to do something like this. And so that was a deliberate decision. You know, they're both lawyers. They didn't quit. They passed the bar. They're doing great stuff. So these are my two that litigated this case with me for a long time. So hopefully that's, you know, an honest way of dealing with it, but I would be untruthful if I told you that there's no cost to litigating cases like this or litigating in general.
Hi, I'm Charlie. I'm a sophomore at Claremont McKenna. Thank you so much for taking the time to speak to us today. It was really inspirational. I'm wondering, if we're ever able to get to a situation where we're able to recognize that the Title IX regulations as they stand really abridge a lot of due process rights, can you envision a world where some of these single investigators who have conducted really flawed investigations, knowingly sometimes perhaps, face any sort of accountability? How would you design that process if you were in charge of it, and ideally incorporate a restorative element in it?
That's an interesting question. So there's a scholar, Jeannie Gerson, and she and Jacob Gerson wrote a law review article that I highly recommend called The Sex Bureaucracy, kind of talking about what you're talking about, that there's this cottage industry now around Title IX litigation, and you have these bloated staffs of people, and they're not particularly well trained, and oftentimes they have an agenda, and what's the accountability for them? And I hate to say this, but the single investigator in John's case who had no business investigating anything. I mean, it was literally insane. I would get a Word document that had like a few paragraphs of kind of stream of consciousness. She didn't record anything. It wasn't a question and answer. I mean, it was, I think my fifth grader could have done a better job. And since then, she started her own consultancy. And, she's getting paid lots of money to continue to do this exact kind of thing. And I find that utterly horrifying because she's incompetent. It's not even just that she's biased, which is bad enough, but she's utterly incompetent and should not be doing this job. And I hope that there is accountability, but I'm not seeing any. What I see is this bureaucracy growing and growing and just mushrooming, and these salaries getting bigger, and not seeing particularly competent people in most of these roles. There are exceptions, and I even made a Title IX coordinator friend, which is amazing. Like, we're actually friends, and she is very competent. So it's not everyone, but it's a lot of them, and it's deeply disturbing because these stakes are really high.
Hi, thank you for coming. I commend you. This is not an easy job to sit and talk about such a overwhelming and heartfelt case. My name is Charlotte Hardy, and I attend Lincoln University, Pennsylvania, small HBCU in Oxford, Pennsylvania. My school is all about reform and due process, and as we know, with Title IX and these flip-flop policies, we tend to go back and forth and make it a left or right issue and not what it is, which is a human rights issue and a First Amendment issue and the lack of due process. And as you stated earlier, the typically only solution is for this generation to go out and vote and to go out and be the typical next voice and to hopefully, and I pray every day, to essentially change what has happened over the past God knows how long. So in your professional opinion, what do you think is one specific thing that we can do now as students and future law students and people who are in law school right now, people who are in the profession, to prepare themselves for the long road, because we're going to have to take it regardless?
I think it is really important to play the long game. So whatever your ultimate goal is, to understand that it's not going to be a linear trajectory to get there. I think, though, sometimes we underestimate how much impact we can have locally, and that in fact there's a lot of grassroots organizing that students and young lawyers and people who you would think, oh, well, no one's going to take me seriously, but these local elections, it really does sometimes turn on turnout, and if you think about them, I mean, it matters. It matters who the district attorney is. It matters who these local officials are. I'm particularly invested in that because of the insanity going on in San Francisco and LA, but the truth is, those types of reformers, which happens to be the kind of reform that I care about, though I realize those are not values that are necessarily shared in this room, they win elections in large part because of enthusiasm on the ground and the grassroots, and that's generally young people. So I think starting kind of small and involving yourself in a local campaign that you care about, maybe it's like the city council, or maybe it's the DA or someone who has control or a say-so in issues that you care about, and just starting out in that way and kind of learning on that level I think it can be really inspiring. It's funny that I say this because, of course, we just went through a recall in San Francisco, but I had never participated in anybody's political campaign until the DA who has since been recalled was running in 2019. And it was a very grassroots effort, and I learned a lot from doing that and realizing like, oh my God, this person that nobody thought could win, like they can if you bring together this sort of motley coalition of people. And so I guess I would say is you have more power than you think and more influence than you think. And then also that it zigs and zags, at least in my nascent attempt to get involved in political things.
Hi, my name's Kayla Blackstock. I go to a junior college, and I wanted to ask about like how you handle the intersectionality but between like sexual assault cases usually being for women filing a case against a man, and then the intersectionality of that and the race aspect, because I probably would have been one of those people who would have called you a rape apologist.
It's okay, you still can.
I don't want to. You bring up some good points now, so that's good. The discussion's always good. So how do you bring in that like believing survivors aspect as being a feminist yourself, and also acknowledging that all things are intersectional and it's not just like a two playing field, that there's more things involved?
That's such a great question. The truth is I've become a lot more empathic in doing this work. I mean, I went from just being so angry in John's case to the point where like I like couldn't even understand kind of like what the counter narrative would be. And then it was interesting, in the middle of this trial I started to understand it. Like the whole way that case went down started to make sense to me in a way that it hadn't before. And that was in part because all the evidence came spilling out. But you're right that it tends to fall along certain lines, but not always. We have a female client who's a sexual assault survivor who was accused, I mean, it was insane, but accused of masturbating in class during a mandatory psychology exercise that involved interpretive dance. So literally, this can happen to anyone. I mean, this can happen to anybody. And the way that she was treated, you know, it was really just as horrible as what happened to John, minus the shaming and the racialized aspect of it, because he was obviously like in fear. So I think it's important to remember that anybody can be accused, literally anybody. But I also think it's really important to think like, okay, well, what's the other side of the story? Like, it reminds me of when you're looking at a painting and you don't think about the negative space. But the negative space is also its own painting. And I feel like unless you can do both of those things and you can see the other side, then you're not going to be able to do as effective a job. I think doing any kind of litigation in a very high level requires that sort of extra degree of empathy, where even if you vehemently disagree, you're like, okay, I can understand how this happened. Like I don't agree, but I understand how this series of events came into being, and I can see what this person, I can see why they're saying it, even though I don't agree. But it did take me a long time, particularly in this context, to kind of get to that point. And interestingly, the thing that's actually been the most helpful for me in getting to that point is what we mostly do. It's not as related to this topic, so I didn't talk about it, is wrongful conviction cases. And that was when I learned the most, because in wrongful conviction cases, you have two sets of victims. Like, you have my client who was convicted of something that someone else did, but then you have the victim's family and the victim, if they survived, who've been lied to all these years and told a story that's not true, and are very angry and often very defensive and clinging to this really ill-gotten verdict, but sort of like understanding how they got to that point, kind of going through that process in the wrongful conviction context has also been helpful in Title IX.
Hi, thank you so much for everything you've said today. My name is Kenna, and I go to the University of Wisconsin-Madison, and I currently work for the Wisconsin State Public Defender. And it's something that I'm really, really passionate about and what I want to do. But I get a lot of negative responses and people who say that I work for the bad guys. How do you respond to people who have such immediate negative reactions to the work that you do now and your past work in public defense?
I will be honest with you. I find those people absolutely loathsome. I really do. Every time someone goes on Twitter and is like, Lara Bazelon defended a rapist, and I'm like, I was a public defender. Those are my clients. Fuck off. I just have I have no patience for that. And when I was starting out, it was like being a public defender, it's hilarious because it's actually a really hard job to get, as you probably know. And then your clients are like, you're free, so you suck. And you're like, you have no idea. Like, I had to step on 1 million people to get into this room with you. And then they'll get a good result. You'll get a good result, and they'll be like, oh, great, you can go get a real job. And you're like, no, I wanted this job, right? So it's weird. Like, everyone hates you. The judge hates you. The prosecutor hates you. Everyone's telling you that it's a road to nowhere, that you'll, like, never become anything. And I think that we're evolving, and I think public defenders are having maybe a moment of finally, like, not being the kid that gets beaten up and shoved in a locker. But still, people are like, well, why aren't you wearing the white hat? And it's like, well, the people in the white hat kind of, they lie and cheat and steal a lot. It's not the greatest thing. So I don't know what to tell you other than I think to push back really forcefully because there is nothing, in my opinion, more noble than that job. And in my heart, I'll always be a public defender. It's like completely the crucible and formative to my entire identity. I would never apologize for it. And I would just push back really forcefully because I think it's one of the hardest and most noble things that anybody can ever do.
That seems like the perfect answer to end on. So please join me in thanking Lara for her time this evening.